So, with your permission, may I start? Good afternoon, everyone. I, Dakshita Dubey, on behalf of Team of Asia Pacific WISP Remote, welcome you all to today's webinar, Oral Submission from Preparation to Presentation. What makes the first Asia Pacific WISP Remote truly unique is that it is one of a kind and inclusive of everyone's participation. The ideology behind this moot is to step out of the ordinary and provide an exposure for holistic development and learning. This is an exciting new competition that aims to give training to young budding lawyers and students to improve their skills in advocacy and arbitration. This pre-moot will be an essential part of training for students and arbitrators planning to attend the WIS moot and the WIS East moot. The skills learned here will also be a key component for future careers in arbitration. All moots, but especially WIS, requires the ability to present arguments before the arbitrators logically, respectfully, and in a way that leads to winning the competition. For this purpose, today we have with us the master himself, Dr. Rajesh Sharma sir, who has led not one, but two WIS teams to victory. Dr. Rajesh Sharma sir, who is currently teaching at RMIT University, Melbourne, Australia. Before coming to Australia, sir was the assistant professor at School of Law, City University of Hong Kong. We have sir with us today to share his expertise in the ideal way of presenting oral submissions. We also have Mr. Gaurav, our ISL interpreter, who is here to make this webinar a more inclusive place. Dr. Rajesh sir, I'm sure our attendees are waiting to hear from you about today's webinar. So I won't take up much time now. We welcome you, sir. The floor is now all yours.
Thank you. Thank you, Dakshita, for your kind introduction. And in your presentation, you have already said about the essence of WIS advocacy, which is presenting the case logically, coherently, clearly, and respectfully to the tribunal. This is the essence. But one question always people ask, that if it is so easy, and if everybody knows about it, then why not everybody wins the case? Why not everybody win the championship? There is something about it which we have to understand. And the WIS advocacy is about that. What I'm going to tell you today is my experience over the years with the team and learning from others. What I'm presenting here is from my own experience. And I have tried and it has worked. So I can say it's a tried and tested, and it's a recipe for success. I can say that it's only a matter of execution. If you think about that, advocacy itself, one cannot say that you can win the case entirely on advocacy. It's not possible. You need to have some content also. So that's why we say that it may not win the case, but it can win the heart of arbitrator and the audience. Winning the heart is also a good quality, so that the people will know that you have done. Very few people have a natural talent of oratory. But we say that as a student, you can develop these skills. Even if it's not natural, you can make it fluent, natural, according to your own style. And that's why we as a coach and we as a teacher, we teach you these skills. And if you follow and master it, you can be a successful mooter sometimes. But first we have to realize what is the problem with many teams or many oratory, that why we have a problem. And there are some common problems you can see. The first and foremost, I say that there's a lack of a style and a structure in the oral advocacy, particularly in the WIS context. It is a matter, it's a problem. Second, sometimes lack of content is there, a problem. And the third is the question and answer skills. And this I find is a very, very important skills which teams should have and the students should have. Another one is a lack of time management. Because you have 4 issues, one student has to present 2 issues in 15 minutes time, and he will be or she will be asked the question by 3 arbitrators, left, right, center. So you have to manage the time. And this is what people say, that in 15 to 17 minutes time, how you can deliver your oratory. And this is a practical skill even as a lawyer. And last but not the least, which I see, is that the arbitral tribunal are there, not a robot. They are human beings. They want to engage with the counsels. They want to engage with the student. They want to have a discussion with them. So most of the team, they prepare their oratory more like a robot, a very straight jacket kind of a thing. They do not make it normal, natural, and engaging. That's what it lacks sometimes. So this is what we have to deal with that. How to overcome? And my simple formula is that there is no shortcut to success. It has to require preparation, practice, and inspiration. You have been working for so many months now. You just submitted your oral written submission for respondent. Now you are starting. You already spent almost 4 months. Still 3 to 4 months to go. 8 months of motivation you need. Endurance you need. Sometimes people lack. This is what you need to do. Practice, practice, practice. That's the key. There's no other way we can say. Only hard way you can find it. The question then that what is the best structure? How we should do? And my suggestion is that even the starting is very important. The moment you open your mouth, the arbitrator or experienced judges sitting over there, they will know that how confident you are, how prepared you are, and how well you are. For example, if you enter the room and it's an afternoon and you tell the tribunal that good morning, Mr. President and members of the tribunal, immediately people will know that you are nervous. So you have to get through with that. And after that, what you need to do in a mooting context, the first thing you need to do is to give a very good start, confident start, well begun, half done. And this is the one thing you need. So a structure, a good structure requires a good introduction. A good start means a good case theory, which is a one-liner, which I will tell you. Then you should have a roadmap that what you are going to present. Then you need to demonstrate your question and answering skills. And then you should have a very smart and creative use of facts and law. Because 60 pages of moot problem have been read by so many people from Vienna to this one, Visist. And you can imagine everybody is reading the same page, same text, but they are interpreting it a different way. And at the end of the moot, rebuttal and sur-rebuttal. It happens in 1 minute, but it makes a great difference. And in a very tight or match, you will find that the rebuttal and sur-rebuttal can take one team as a champion and the another team as a runner-up. So this is what happens. Apart from that, a good conclusion is also a very good thing, which you need to have that. Now, what we do in introduction is that introduction, we say that well begun, half done, means start well, be confident, show your professionalism, everything. And this is very simple. 8 o'clock mood, if you are coming and you started that, you have not spoken, your throat is completely choked, you start, good morning. So people will, oh, what is happening now? But you can prevent it. You can do it little early. You want to cold water, hot water, do it little, open your mouth, say something, sing your national anthem, and you will be inspired. Your throat will be open and you will be fine. Even saying good morning, good evening, it matters. Looking at the time, 2 teams competing. At 12 o'clock, other team is starting at 12:05. They look at the time and then say, good afternoon. The tribunal will understand, oh, you are very vigilant. You are looking at the time and you are very good at that. Even calling tribunal as Mr. President or Mr. Chairman makes a difference because both terms are of the same dignity. But according to the rules of arbitration, in one tribunal, one is Mr. President, another is Mr. Chairman. Sometimes the people also use honorable tribunal or anything. Arbitration is very informal. You don't have to have honorable. It's not ICJ. It's not a Supreme Court judge. They were just normal. So you have to be honorable tribunal in that case. When you have been given all these things, you have to introduce yourself and your partner. And you have to tell the time and you have to reserve the time for rebuttal. Team or students do not realize for sur-rebuttal is not your right. Rebuttal is your right as a claimant. Sur-rebuttal is not your right. So if you do not reserve the time for that, you will not be given. So you should reserve the time, and it shows a kind of clear-minded in the people that, okay, this is what you should do that. Most of the time people introduce themselves and then other partner does it on their own introduction. That's fine, you can do it, but it takes time. It will take you another 60 seconds and 1 minute time to pass here and there. So why not just to do it? For example, you can say, Mr. President, members of the tribunal, I'm Rajesh Sharma and I'm appearing on behalf of claimant, and I will present my case for 14 minutes and reserve 1 minute for rebuttal, and my co-counsel will present for merit, and she will also, or he will also take 14 minutes time and 1 minute for rebuttal or rebuttal. That's it. In such a clear way, you can finish it. You save time, you move, because you don't have too much time. Now, once you finish that, then you have to start your argument. And this is the part where the whole structure starts, and it shows which team is how much they prepared. Now, we say that as a claimant and respondent, you have to present your case, and first you tell that you are claimant or respondent, then you have to present your case in such a way that you tell them that one liner, what is your case about? And this, we call it case theory. This comes with a practice. For example, if you are presenting your case where the breach of contract is an issue, and you are contesting that the contract is not even formed, then what you will do? In that case, you can say that, Mr. President and members of the tribunal, this case is about something. Or you can say that, Mr. President and members of the tribunal, my client has been dragged into this arbitration for breach of a contract to which he has not even entered a contract for. So something one-liner is, you can do it, a short sentence, so the people will know that what you can get it, what you can do it, or what is your case is all about. Then another thing to think about it, a simple way to start, you can say that this case is about, my client case is this, or you can say that tribunal should rule in our favor because of these things. It's a very simple short sentences which you can use it. If you want to know about the demo of this, here is the link which you can click and you can find it. All these advocacy videos are presented by the champions, and you can see how they have done it. This is just an example to show it to you. After finishing your case theory, you have to give the roadmap to the tribunal that what are you going to argue. In argument part, you may have to say that how many arguments you have, how many reasons you have to give. For example, you say, Mr. President, members of the tribunal, we have two issues here, one on jurisdiction, or one in a jurisdiction of the tribunal, another one on the rules, and I will issue this. Under this, I will have so many two arguments. So all those things, you will give it to them. Now, if you have two issues, you give two issues. First issue, second issue, all those, you can say that. You can give arguments, sub-arguments, you can do that. So in that way, you can tell the tribunal that under the first issue, I have so many sub-arguments, 1 and 2 and all. You see, people may not remember the words, but if you say 1, 2, all those things, 3 facts, 1 arguments, all those things, the number hits to them and they remember that. Okay. And then you can show to them that under the first issue, we have this argument, and you can develop those arguments. This is nothing. This is very simple, a logical way to tell that I will present 2 points under 1 point. I have 2 sub points, and I will follow one by one. So in that way, there will be no mixing, and the clarity will be there. Now, after this, what happens? Most of the team, according to our experience, I can say, they do a very good start, good introduction, good roadmap, and they start using it. But once the mood moves more than 2 or 3 minutes, the team starts losing their structure, and the tribunal do not know where they are. So if you have given the sign, or if you have given the roadmap, you have to tell the tribunal where are you, which point you are arguing, and how you are moving the argument. Particularly when the questions are asked, team definitely start losing the track of their argument. For the solution is that you should use some of the signpost words. For example, in our first argument, we are doing this. Moving on to my second point, moving on to my next point, going back to my first issue. If you say like this, then tribunal will understand that, that's how you are moving from here and there. This is what you will do. But after this talk, after this discussion and presentation, there's another tendency is that the team always, they say that if you have no further question, if you do not have any question, then I will move forward. Our suggestion is that you don't have to use it, because general tendency would be that if you tell the tribunal that you have no further, if you have no question, then I will move, then the tribunal will definitely ask you a question. It's not that you are running away, but you are stopping yourself from moving forward. In your structure, this should not be the part, but you are welcoming the question. There is no doubt about it. So this is signpost is very important that you should give it to them. While you are arguing, we say that in arbitration mood, you have to remember the facts are very important. And we say that the facts are friends, because the same facts are used by everyone. So people want to see how you are using the facts. Law is important, but after the facts, not number one, is number two, is there. Policy is the last argument. If you do not have any facts to support, if you do not have any law to support, then you can use policy issue, and that will be very good on that one. All this, our suggestion is that you should structure your argument where you should give your presentation and you back your argument with facts, then law, and then policy. So this is a 3-layer argument which you will be presenting. And if you look at that and if you execute it, you will find that your argument is very intellectual. At the same time, it's very easy, and it shows your creativity of using the facts. Same facts, same line, same words, you can interpret in a different way to suit your condition, suit your client case, and you can do that. So this is the thing, you should think about it. We say that when you are referring the facts, you should be taking care of one thing. Generally, what happens is a 60-page document, 65 pages. What happens that they say that look at the claimant exhibit number 1, and they say that paragraph 3 and all, and then they say page number at the end. You see, if you are looking at the a document, if you tell me that look at the claimant exhibit number 1, and I don't know about the mood problem, then I don't know where to find it. I cannot find it. So isn't it is good that you tell me the page number first? So if you say, look at the claimant exhibit number 1, page 33, then immediately I will turn the page 33. Then you can say paragraph 2, 1, whatever, and then you tell me the line and I can read it. All these things is very easy, and the one way you can achieve that, you are holding the hands of tribunal, taking them to the right spot, reading it the document, and read with you, and also they can understand and they can use. So clarity, an easy way to do. If you make the life difficult for arbitrator, they will not like you. While you are turning the page and all those things, some arbitrators are very fast as a coach, or they know the mood problem very well, so they can know that what you are talking about. If not, then what happened that you can start working on that. If somebody is slow, then what you can do, establish an eye contact and wait. So you can say claimant exhibit number 1, page 33, then look at the tribunal and see who is turning, who is not turning. If somebody is flipping through the page, then you can say that. After that, you can say that, oh, well, you can wait for that, and you see that they are turning, and once they reach to the page, you can paste your sentence like that. So you can do like this. May I invite the tribunal to see page number, claimant exhibit number 1, page 31, line 4 from the top, and look at that. And then once if they are there, you can start reading the line clearly on that. But don't wait forever. If they are not turning, means they know about the case. You can go. Referring of the cases is a trick is that you should first tell the name of the case. Name is very easy. If you say A versus B, it is very easy to remember. But if you tell that citation like, case file and the citation number, ICC case number, all those, it will be a little difficult. Another thing you should do in the citing of cases, that you should highlight the new cases first. If through your research, you have found the new cases, you should highlight that. It will impress the tribunal that your research is updated. And say, for example, moot is in April or in February, and you have a case from January, then it shows that how latest cases you are using, how good you are at research. And that creates a very good impression about the team. So you need to do that. Particularly if it's a new case, you should emphasize the year. Make sure that you tell it in such a way that tribunal listen to you, that this is the latest case you have found. If you have a lower court and higher court cases, try to give the higher court case first, or the tribunal cases. That in that case is very good. You should also, when you are telling that case you are relying on, and if it's a very good case and it goes in your favor, then you should also quote the correct line from the case itself. If you paraphrase, then you might miss the good point. So it's better for you to quote from the case and give the page number of that case. It will establish the credibility about yourself, that you know what you are doing, which case you are using, and how you should use that. Nobody will challenge you in that case. So they can go to the case, look at the page number, and they can find it. If you just paraphrase, it will not be a good idea. Okay. While you are using cases, you should always remind, and the tribunal has a very trap questions. Trap questions are something that first thing they will ask you, what is the facts of that case? And if you're just relying on the case and you don't know the facts of that case, you will be in trouble. So you should first, if you are relying on the case, you must know the facts, and you should know very well. In arbitration, it's also important that you should tell them that law which they are using is which law they are using. For example, if it's a common law case based on the local contract law, which is not related to CISG, it will not be relevant. So you should know that whether the case used CISG, if it's an arbitration case, which rules were used, and all those things. So ideally, you have to remember that all these cases, you must remember from the back of your hand. Facts, who decided, when decided, what was the decision, what was the facts, how relevant and how close these facts are with your case, you should do that. Again, it increases your credibility with the tribunal, and they will be very happy with that. At the one, in arbitration, generally you will find a question, is it binding on the tribunal? And of course, binding precedence concept doesn't apply in arbitration. So you can say that, of course, it's not binding, but it's very persuasive. And this is what you need to do. If you're using other authorities like book, journal, commentaries, and all those things, again, in that one, the way you do the citation, you should do it in the right. First, you should tell the name of the author, title of the book or the title of the paper, name of the journal where it is published, year and page number, and then quote from there. In arbitration, Gary Bond, other people are quoted very well. In CISG, Professor Swenger is quoted very well. So you have to do very nice quoting in that one. Moreover, if you are relying on any article, know about your author, because you will, if somebody has found something from Wikipedia or Google or some kind of a blog, then in that way, you will not find it, who is the author. If they ask you, who is this author? I don't know. Maybe a student or ex-mooter who had just published. Is it something that you want to rely on? Is it a good authority? No. So you have to be careful about it. And one thing, if somebody is sitting on your judge, he is also the author of the book or article which you are relying on, you should be careful about it. If you are using that one, you should know it very well. It may be possible that you will say that I'm relying on this, and they will say, no, this is not what I said in this case. No, this is not what I meant. So it might be a difficult situation for you. So be careful when you are using it in that case. Now, in arbitration, in Wismut, particularly, we have seen the use of drafting materials are very, very important because people read the books, blogs, and all those things, journals. But you have to go and read the whole idea, the discussion, how the CISG, any paragraph or any article which was written over there has been written with very, very good preparation. Many countries, many delegations, they asked this question, deliberated on it, they were voting on it, and you should remember about that. If you read those documents, you can find so many answers to your moot question, and you can make a very good presentation. Moreover, it helps you to demonstrate to the tribunal that your research is so good that you have gone behind the scene, you have gone deeper into that, and you have found. Many times we have seen the teams using, and our team has also used it, some examples, and presenting it. For example, they said that, oh, the way the other team is interpreting the CISG article, the same way it was attempted to interpret in the drafting moment and in the Vienna Convention, but it was rejected by such and such vote. If you say these kind of things, it establishes the credibility. And whatever you say after that, it will be very well accepted by the tribunal and they will not challenge you. So preparatory document of model law and the CISG is very important, and you should definitely read it and understand it. That main part of the question, most of the team, they think that I have prepared my 15 minutes of presentation and I should be able to deliver it without disturbance. And if it happens, they feel very happy that, oh, I presented very well. But they miss one point, is that they have presented like a robot. Tribunal has listened, but whether they understood it or not, that's the problem. Therefore, in the moot, you will find the questions are asked, and particularly the questions will be asked on you to find out that how much you have understood the case, understood the law, how far you have done the research, and what is your ability to answer the question. So I say the questions are good for you. If you want to win the moot, don't avoid the question. Ask them to ask question. If the questions are asked, you answer them and answer them immediately. And when you answer, it is your moment to show to them that how much you have worked in 8 months on this case and how much you have done the research. You should demonstrate that. Don't avoid the question. That will be the wrong thing to do. If you want to see some techniques of answering question, we have a link here. You can use it. And the same resource, you can also find it on the Moot website under the resource section. And you can see that. And it's a small segment of 5 to 10 minutes, 5 minutes video. You will like it in that case. And you will learn it from there, from your own practice. How to deal with the question, because most of the people who are coming in the moot problem, they come from the different linguistic background, different cultural background, accents are different, their wordings are different. So sometimes you will have a problem in understanding. So when the questions are asked, you should stop immediately and answer. But if they ask you a question and you do not understand, then you should not answer that. You should clarify the question in that sense. For clarification, you can say, if you just simply say that, oh, pardon, I didn't understand your question, I didn't understand what you asked, then it will not sound very good. It will be very rude. What you need to do is say that if Mr. Arbitrator is asking this, and then you add what you understand. If this is the case, then you can say that they will, if the question is the same, then they will tell you that, yes, this is my question, and you answer. But if their question is not this, and they are answering you in a different way, and they have a different question, they will stop you and say that, sorry, this is not my question. And they will ask you different. But tribunal also have a tendency of asking tough questions, and they will ask you the tough questions on your weak point. That's fine. It happens, and you be ready to answer that question. But if they push you too much on that one, then you can give them an idea that how important this question is, and you can tell them that whether your case is related to this or not, or you can say that whether you are using this question or using this case on your client's behalf, and whatever the facts has been given, you are using that one and use to the fullest, and that's what you rely on that. Many times it also happens that questions are used is on opponents. So when the opponents are arguing, you should listen to the questions what has been asked to the opponent. Do not ignore those questions, because when questions are asked to other party, they listen to them and you understand what the answer they have given, and you should take note of that questions. So when you are presenting this question, you can make it into your argument. For example, you can say, Mr. Arbitrator, while answering to your question on this point, the team has said this, but they are wrong, or they have not given you complete answer to that. You can give this point on that. And that's how you can use the question for you. Again, for question and answer session also, we have this link which is given here. You can understand on that one. Question and answer is not taking your time. You can use this one in a good time management. For example, if you are trying to adjust your meeting, adjust your question and answer, then while answering the question, you can formulate your argument in such a way that you can move your argument. For example, you can say that in order to respond, you say that when they're asking the question, you can say that, Mr. Arbitrator, we are exactly arguing this point, and this is the exact reason why you are arguing this point, and you can move your point of that, and you can formulate your argument. Another thing I suggest, that since question takes time, people also miss issue, and they say, oh, there are so many questions on issue 1, then I cannot answer that one. So what happens is that they miss on the point, and last time and at the end they start flustering on that one. We suggest that every item, every issue which you have prepared, you should prepare for 5 minutes, 3 minutes, 2 minutes, and 1 minute. Of course, more than 5 minutes is good enough for you to answer one issue, but you can do issue by issue. So in that case, I suggest that you should try and do that. It sounds very hard, but I tell you, it's not that so hard. It's very easy for you. Okay. With your team partner, you can also show some kind of a signal in that one. If you are losing the time, or you are reaching close to that, your partner should tell you that how many minutes are there. And we have seen different technique. People use red, green, and yellow color of a tag to show it to them that how many minutes are left. That you can work it out. For example, your partner can tell you the 2 minutes left, 1 minute left, 5 minutes left, and this will help you in keeping track of your time. But with practice, you will know which argument and to what extent you have to argue to move your argument. There's nothing in that one. Even if the time is less and you have no extra time, even 2 minutes or 1 minute, you don't have to rush through the argument. Easy, as if nothing has happened. You are ready. Your case you have prepared, you can do it in 1 minute. Don't rush, don't speak fast, don't fluster. You speak to understand, because you are communicating to them. You put forward your strong point because you have a short time, then you say a small point. You just say that, Mr. Arbitrator, this case, you have to just decide on this point and just explain the point on that. If you have so many alternative arguments, you cut it down. Don't do that. Just focus on that one. If you need extra time, there's no harm in that. You can get 1 or 2 minutes extra time. Actually, you can get only 1 minute extra time, but some liberal tribunal can do you 2 minutes. But a good team, a good student should ask the extra time before finishing the time, not after finishing. And at the very last moment, if you have been asked the question and you are finishing the time, then you can say that, Mr. Arbitrator, may I get 1 extra minute to answer the question and conclude my argument? You can do that. As a respondent, if you are arguing, the whole thing you can follow the way I have explained to you, with one change. One change is that the job of a respondent is to respond. Okay. So when the respondent is responding, he's responding to all the arguments given by the claimant. Okay. In that case, what you can do is that you can first give the argument, and you should be answering the question, answering the arguments of claimant directly. And for that, we can say like this, that Mr. President and members of the tribunal, I will answer the question, or I will answer the argument given by the claimant, and I will respond directly, and I will argue the point in the order it was presented. You can make it like this, or you can follow the structure, what the claimant has argued, and you can follow their understanding in that one. What you should do, not just to start the argument on the issue, you should always connect the argument given by the claimant. For example, if it says, claimant has argued, Mr. President, claimant has essentially argued this point. And then you go and attack on their point by point, layer by layer, and explain to that. Your action should be like a surgeon. You have to do item by item, point by point, you cross them on that one. And this is the job of the respondent, which you need to do. And you can add sentences like that. The claimant has argued this point, but they are wrong on facts, they are wrong in law, and all those things. You can argue that. So you can tell the tribunal that you are familiar with the case, you listen to the argument presented by the claimant, and you are going to respond directly to them. These are the points, like, you can make on that. When you reach to the conclusion of the case, most of the time, when there is not enough time and a few minutes left, then what happened that they start running around. They start closing on, doing very fast on that. We suggest that your closing should also be like your introduction. Introduction gives the impression, and conclusion also maintains your reputation and your standard. It's like landing the aeroplane. If the plane is landing very softly, then you feel happy. If it's abrupt, nobody likes it. So this is what you should do. Your conclusion should be in line with the case theory. The case theory, the way you open one-liner, your conclusion should also be like that. But at the same time, your conclusion should be like a big thunder, a big bang, so that once you finish, the room should resonate with your conclusion, which you have said. So the tribunal, when they go to deliberation, they should remember what you said. And in that way, you put the impression or create the impression on them, and they will remember. And they will remember your argument. So it's very important to do that. A simple conclusion. Many times the team, they just conclude, even without saying that they concluded the case, they just sink into the seats. That is not good. So we suggest that you do very nice conclusion. Even if you're running out of time, take 30 seconds and respond to it. Okay? Now, rebuttal and sur-rebuttal. This is also a technique. Let me tell you about the rebuttal. Rebuttal you can prepare in advance. It's very easy, because if you're claimant, you know the respondent case, and you know what respondent will argue. They are arguing your point. You see that what they have argued, you listen to them. You have 15 minutes time to listen to them, and you can prepare. And when your time starts, you can come and say it very fast. There's no problem. You can even prepare for every point. You can prepare few questions, few rebuttal points which you want to say. This you can prepare very easy on that one. But the technique of rebuttal is that it should be short and it should be sharp, because you are doing 1 minute. In 1 minute, you can't say so many things. So be very clear about it, very sure about it, on which point you are going to do. If it's wrong on the facts, respondent has said something, then definitely you should catch them. If they have done something on law, cases, law, and it's cited wrongly, then you should catch them on that one. So basically, if your rebuttal is in your strong area, then it's weaker for the respondent. If you fight a question on that one, a strong point, then it will be very difficult for them to argue. So that's how you can prepare basically. We suggest that you should do 2 points of rebuttal because you argue 2 issues, then do 2 points of rebuttal. In rebuttal, no new arguments. Don't add anything extra. Just rebut on the point which you have been given. Again, this technique is very good, and we have given you a link here. If you look at this link of oral advocacy, you can see in video of that how it is done, how the students do, how the mooters have done. You will see that one. Okay, so that's the rebuttal. Sur-rebuttal, according to me, I really feel that sur-rebuttal, you can't always be ready because you don't know what the claimant is going to rebut, but you may have some guess that what they can do. An interesting point is that if sur-rebuttal is very good, then we appreciate more. Why? Because the claimant has 15 minutes to listen, prepare, and deliver. But respondent has only 1 minute to listen and immediately come. There's no preparation time. So if somebody is doing a very good sur-rebuttal, after the rebuttal, then we should appreciate, and they really do it. So this is what you should be there. And like rebuttal, you can prepare some rebuttal that, okay, because you know the cases of both sides, but this is what you should do. Technique, if you have 2 rebuttals, then you should have 1 sur-rebuttal. 1 less than what claimant has said. So ideally, you should have that. And we also said that ideally you should have 1 sur-rebuttal or 2. Again, you need to ask your time, reserve the time for sur-rebuttal if you want to go. If you have not done it, you may not get it. And some of the travels may not give you. So you should do that. Which point you should pick is entirely like, practice, gut feeling, which you have to use it. What they are giving you as a claimant's argument, rebuttal, you have to only pick on that one. So you feel of that, but with practice, you will have that feel also. You will know that. So this is what we say. Some of the extra facts in advocacy which works is a smile. Many teams are very tense. They don't smile. You ask questions, they feel very angry. You can see the red. I tell you, if the team shows that kind of a frustration, then it's not very good and they don't do well. We have seen the teams mooting on a tough point, in a very weak point, and they know that they are very weak. Tribunal asks the question on that point, and still they give the answer with a smile. That is a communication that I know we are in a weak point, but this is my best argument, I'm giving it to you. So that tribunal will also understand and they like it. Jokes, analogy, another, it may work, but if you deliver it very well. I have seen some teams doing this one very well, but I have also seen the teams which they have not done very well. If you're giving the jokes or some kind of analogy, please be mindful of the culture and the tradition and the place. And I have seen like example of pizza, example of burger may not work in the Asian context. So you need to understand that. Dressing sense also works. So it should be a professional dressing and not very, I said outrageous or very that. So decent professional as a lawyer, which you do. Timing of drinking water is also very important. You should drink the water before the moot, or you should also do it in the moot if you required. But the timing, if I ask you a question, then you drink the water, you can understand what I will feel. I will feel that you are like disturbed by my question and you don't know the answer. That's why you are drinking the water. But when I'm asking the question, then you drink the water, there's no impact because you are thirsty, you are doing it. But try to avoid that. But if you have to drink properly. Again, like introduction, I say the warming up of the moot is very good. And I suggest to the team, because we are mooting from different time zone, different time allocation, 8 o'clock moot, even in the evening moot, we have to do that. In your practice time, you try to do that. If your moot is at 8 o'clock in the morning, I suggest that you should practice your moot at 7 o'clock in the morning, 1 hour before. So your body, your mind will adjust to that. If it's an evening moot, 7 o'clock, then you should do it 8 o'clock so that you will understand that point. So all these things are very important. Okay. So you need to do that. Finally, I say that preparation, coaching, briefing is all these things which you have done. it will remain outside in the room. Once you are on the table, once you are in the room, you are the one, nobody else. And you have to deal with that. Your coach will not do anything. Nobody will do it in that case. Once the moot starts, you are on your own. You don't have to worry about that. So the skills which we have given you, it will help you. It will prepare you. But your instinct is also important. Your gut feeling is also important. For example, out of 4 rebuttals, you can do 5 rebuttals. You can present so many items, so many things, so many arguments. But at the time, you feel that this argument might work very well, or this rebuttal will be very good. It is your gut feeling which will work. You should do it. And take an example of a football match where the coach will tell that if you have to make the goal, you can do this, you can pass here, you can run here, and then you do it. But in the match itself, if there's a situation where there's a goal post, somebody is over there. Do they wait for the coach's instruction? Do they wait for the left flank, right flank to come and the pass and then do it? No. Full goal is the ball is there, goal post is there. Just kick in, make the goal. That goal can be the winner goal and you will be the champion. So all these skills with the practice can make you a good team, a competitive team, a team which can go further. But winning is like also your instinct. So preparation is 90%, 99%. 1% of your gut feeling also you can use it, or any proportion you want. In that way, these are the things you can use it to make your team a competitive team. Competitive team in the future, with the practice, they can keep on moving forward and they can do very well. So what I suggest at this time, that you watch our video, which we have given the resources to understand. But oral advocacy, you have just finished your written argument, memoranda. So now you should start practicing, and slowly you can go. Again, there is no shortcut to success, but it's like building the building. You have to put every bricks in line. Everything has to be in line. So very small things can make a big difference. And ask the team which has lost the championship with one minor mistake, one small mistake, and ask the team who has won the championship by putting everything in line, everything properly. So construction takes time. Destruction doesn't take time. So for our case, I will suggest you preparation, follow this structure, and you will do very well. So thank you very much for your time today. If you have any question, I'm happy to answer.
Right, sir. Thank you so much for your wonderful presentation. I'm sure everybody who's present here must have learned a lot from it. We are now open for questions. If there are any questions, please feel free to write them in the chat box. For the ease of everybody, I can read it aloud, or sir can also read from the chat box itself. Please feel free to type your questions in the chat box.
I can see in the chat there is some question. It's one question is, how comfortable should a speaker be with the facts of the cases and awards cited? Well, if you're talking about the facts of the moot problem, this is very good for that, and you should feel very comfortable about it, because those facts are agreed facts, and every page, every evidence, and every exhibits given over there are accepted, and accepted by both parties. So nobody can challenge that. So far as awards cited questions are concerned, if you are talking about the awards cited in a memo, then in that case, you have to do the research to find out whether the award is on the right point or not. And that will be very good for you. If the other party is using that award and you know more about it, then you can counter that and you can present an argument and you can show that you know more about it. The tribunal will appreciate you on that point.
Right, sir. Thank you. We have another question from Jagrit Verma. He says, sir, can we weave our sur-rebuttals into our argument, given that the tribunal may or may not give us the chance to give a sur-rebuttal?
Very good. And that's why I say that if you look at the argument of rebuttal, argument of respondent is not an argument. Actually, it is a rebuttal of claimant's argument. So basically, as a respondent, you are doing the rebuttal in any way. And that's why the respondent doesn't get the sur-rebuttal. So of course you can use it as your argument. And actually this is your argument. For example, you say, Mr. President and members of the tribunal, on issue 1 or on jurisdiction, the claimant has essentially argued these 2 points, but they are wrong on this. And then you give your reason. And when you give your reason, is actually your reason which you are giving it. So, and that is very important. The tribunal will know that you listened to the argument, you understood the argument, you recap the argument, and then you attack. So it's a very linked argument and very interactive argument. So it will be very much appreciated about that. Everybody has said that the link which I have given here is not working, but I tell you one thing, the same link, you can find it in our resource section. And last time we see it was working, but I will check again, but it is working. So if the PowerPoint is not helping you, maybe on YouTube or another, you can go to our resource website and use the same link, cut and paste and put it there. It should work.
Right, sir. I have a question from Akshita Rohtagi. Akshita says, does voice modulation hold as much weight as the merit in actual arguments?
Voice modulation, yes, it does make sense, because if you look at the 30 minutes or 40 minutes of mood, if it goes like so flat, the people do not feel very happy about it. So early morning mood or the after lunch mood, these are very difficult time you will find, or the late evening mood. It helps. But if you think about it, if you have a good pauses, if you have a good intonation, then it makes. Sometimes in order to attract the attention of the tribunal can also be very useful. You can say that if you say, for example, you want to emphasize on certain point, you can say, raise your voice a little bit, Mr. Arbitrator. And then when you say, they will listen to you. Mr. President, then they will listen to you. So this is what you can do that. So yes, voice modulation works very well. In voice modulation is very good if you are quoting any award, any case, anything, facts from there. When you say it nicely, it works very well. I have seen team members who have, in my team, there was a one tutor whose voice modulation was so good that once he was quoting it, a citation, I see the judge's faces and the head going like this, reading with him, and the man said, this is it. And the tribunal said, yes, it is it. This is it. So it moves like that. So yes, it does matter.
Right, sir. Thank you so much. Oh, just when I was about to say we don't have any more questions, we have one more question. I'm sorry, I won't be able to pronounce the name correctly. It's Kyu Chinksi, if I'm not wrong. But the question is, what if we are asked about facts that were not provided in the record? Because some arbitrators may not be very familiar with the record.
Look, they will not ask you a fact which, if they don't know, then they will not ask. But if they don't know and they are saying this one, then you know what is the correct thing. So you tell them that this is the correct thing. Or you can say that, I'm afraid, Mr. Arbitrator, this fact is not there. The closest thing is this. And then you can say, and actually this will give you very good opportunity for you to demonstrate that you know the facts very well and how the opponent doesn't know very well, and you can add it. And again, showing them the page, the right place is very important. You show it to them, take it over there, and they will understand in that case.
Right, sir. I think that this is going to be the last question of the evening. The question is from Kanchan. She asks, can we change our oral arguments from written submissions? Because we might find new things as we keep researching.
In the Wismut, you are free to do that, because in the WIS mode, your written argument doesn't guide your oral presentation. You can have written argument, whatever you have, but the oral argument can be totally different. There's no problem. Even it may be possible that your written argument is nothing, but your oral argument can be very good. So you don't have to rely on that. Always, and discover new things, do new things, research more and present it in that case.
Right, sir. Thank you so much. There are no further questions, sir. So with your permission, I would now like to conclude the session.
Thank you.
Right, sir. It was an honor for us to have you present with us today, sir. Thank you so much for taking out the time from your busy schedule for us. We look forward to our future webinars and are extremely excited for the first Asia Pacific WIS pre-moot. Till then, I hope everybody across this forum keeps safe. Have a good evening, everybody. With that, I shall now be ending the meeting.